Good morning. On behalf of the Australian Government, it's my great pleasure to welcome you to the 2014 Australasian STEP Conference. Might I in particular welcome those who've come from overseas to enjoy the beautiful city of Sydney and to participate in what will be a fascinating program. When my friend David Russell asked me earlier this year to attend this conference, I accepted immediately. I had hoped to be present personally and perhaps even to revert to my earlier persona as an equity lawyer and present a serious paper. Alas, the vagaries of the Senate Estimates Committee program have meant that I cannot get away from Canberra, to my very great disappointment. Australia, and in particular Sydney, has for a very long time been among the most fertile centres of equity scholarship in the English-speaking world. Many of the most influential leading judgments in equity and trusts are those of the High Court of Australia and the Supreme Court of New South Wales, and many of the leading equity textbooks are the work of Australian judges and equity scholars. In that connection, I note that one of your keynote speakers is Dyson Heydon, one of the greatest of all contemporary equity lawyers, whose contribution as both scholar and judge has few equals. I'm particularly disappointed not to be there to hear his paper, the preparation of which has not, I trust, distracted him from the other important work on which he is currently engaged. Let me take the opportunity to say something about the Hague Convention, which I know is of particular interest to you all. The government recognises the key role that trusts play in the Australian economy as vehicles for saving through superannuation, small businesses through family trusts as business operators, and collective investment vehicles through listed trust structures and real estate investment trusts. The internationalisation of the Australian economy has resulted in trust-based economic activity crossing borders as never before. In this connection, the Trust's Hague Convention will become an increasingly significant part of Australian private international law. As with all areas of law, trust law needs to keep pace with the times. Matters that over time will require attention from governments, state and Commonwealth, are the interstate trust recognition rules, to which of course the Hague Convention does not apply, and the developments in international trust law in such areas as the rule against perpetuities, which as you know has already been abolished in South Australia, and remedies for trustee errors in the area covered by the so-called rule in Hastings-Bass. The government will monitor these developments with interest and, where necessary, act in conjunction with state and territory governments to ensure trust law in Australia remains suitable to modern conditions. STEP's established international reputation as an advisor to governments will ensure that it will be one of the sources of advice to Australian governments in this process. And with those words, I'm pleased to officially open the 2014 Australasian STEP Conference. I wish you well in your deliberations. Have an enjoyable few days.